Good afternoon. Welcome to our webinar. Today's topic of conversation centers around House Bill 1202, Peace Officers Accountability Act. This webinar is recorded so that it can be viewed at your convenience. If you have questions, feedback, support, please kindly send us an email afterward at my-linthai@ledge.wa.gov. After a public outcry over police misconduct and a lack of police accountability, Washington legislature took decisive action and passed a package of bills designed to improve policing in our state. It is my honor and my duty to prime House Bill 1202 to highlight these intents. Number one, to hold governmental entities accountable who have the power to adopt policies, to allocate funding, and to support appropriate trainings for peace officers in their jurisdictions, ensuring public safety for Washingtonians. To provide a civil cause of action for victims and family of victims whose constitutional right was violated by actions committed by peace officers. And number three, to ban the use of qualified immunity as a defense under Washington state jurisdiction. I welcome our panel today who will speak to the why we need this legislation, the what this legislation, when passed, will do, and how House Bill 1202 serves as an accountability legislation to correct an unjust system toward the very citizens it intends to protect. We welcome the representatives from the impacted families, Ms. Katina Johnson and Mr. Fred Thomas, Ms. Enoka Herat from the American Civil Liberties Union of Washington, Mr. Michael Transue from Washington State Fraternal Order of Police, and former judge and former state representative, Mary Kay Becker. First, we will hear from the representatives of the impacted families. Welcome.
Thank you so much, Representative Thai, for having us this afternoon. My name is Katina Johnson, and the why 1202 is important is because police in Washington state have killed over 100 people in the last three years, and very few cases have been brought against police, let alone compensation for those families. We need 1202 so that families can get information and an explanation as to what happened to their loved one, just like in the case of my cousin Charlena Lyles. And we have to use a federal arm in order to begin to get those. And as we all know, that when we want change, it has to happen it starts in our counties, in our state, and then federally. So we are already working on things in our counties, and we need this at a state level so that everyone all over the state of Washington and every Washingtonian can feel safer in their communities if something was to happen to their loved one, and to know that they can get the answers that they need and the compensation that comes along with that in the event that something tragic happens. And I'll turn it over to Fred.
Fred, you're muted.
Okay, thank you. Good morning, and thank you, Representative Thai, for this space that you provided us. The whys, and I've gone over this a lot, and it starts off with one, to hold police accountable. There has been no accountability for centuries when the police choose to take a life. But this law only applies to those who break the law, for those who kill unnecessarily. 2, it takes responsibility off the backs of the families who must suffer in silence with no recourse for the wrongs that have been done to them. A good point that 1202 makes is it brings it home, makes it local. Federal cases, first off, take way too long and are way too expensive. We've been through one. Another big point that 1202 makes is the attorney fees. It allows the prevailing party, you have to win to recoup those costs. What good is winning a $100,000 award if you spend $1 million to win it? It cost over $3 million to put on our case, and that does not include attorney fees. Making it local will hopefully bring swifter resolutions and bring the cost hopefully way down. But the biggest thing it removes is qualified immunity. Had the defense, in our case, used qualified immunity in the very beginning, a jury would never have had the chance to hear the case. The truth would never have been brought out. The mistakes they made, which they're still doing their best not to learn from, would still be overshadowed. We are asking not only for accountability, but to bring into the light the wrongs that have been done to the citizens of the state of Washington for too long. We ask for everyone within earshot of this to please lend your voice to the passing of 1202. It is important for both the innocent and the guilty. Thank you.
Thank you. I wish that we have more time so that we can hear more personal story from both of you. I want to thank you for taking the time and come and share with us. Ms. Johnson, could you just share with the viewer if we have viewers or the public that would like to engage and involve with impacted families? Is there a way that they can reach out and support you? Or there might be a victim families out there that wanted to learn from your advocacy. How do they reach out to you?
I'm pretty easy to find, but you can reach out to me via Facebook. You can reach out to me via my email at johnsontrina64@yahoo.com. And my number is all over the place. It's not that hard to get a hold of me. So one Google search and you'll find everything you need to know about me. And I'm always ready and available to help impacted families. It's part of the work I do locally and nationally.
Oh my goodness, that is so generous of you. I was thinking more of the coalition's contact information.
The Washington Coalition for Police Accountability it's definitely the way in which you could get a hold of all impacted families who are doing this work, making legislative changes for the great state of Washington. I think that Enoka, you know the email. I don't remember what it is.
You can follow the Washington Coalition on Police Accountability on Facebook and on Twitter, and the contact information should be on those pages.
Great. Well, thank you. Thank you so much. And now we move into the what. I'd like to invite the next panelist into this space of conversation. Ms. Herat from ACLU and Mr. Transue from the Washington Fraternal Police Order. Fraternal Order of Police. Now I get it right.
Well, thank you for having me. I want to talk a little bit about what this bill does. This bill is about responsibility, as Fred mentioned. The Peace Officer Accountability Act promotes public safety by motivating police departments across the state to align their policies and practices with state laws and the Constitution. And it requires them to take responsibility in hiring, training, supervising, and disciplining officers. It recognizes that departments are in the best position to push for better policies and practices and outcomes for police. This bill is also about fairness. When an officer violates our rights or the rights of our neighbors, we expect consequences. Yet under current law, significant barriers to civil accountability result in a lack of consequences, and it's simply not right. This bill allows victims of police violence and misconduct to hold police accountable without the shield of qualified immunity. So what is qualified immunity? Qualified immunity is a legal doctrine that shields police officers from accountability by requiring proof that they violated clearly established law, putting the burden on victims to find a nearly identical court case holding another officer accountable. It's a key element of officer impunity, a get out of court free card, and it's kept police above the law. And advocacy groups on both sides of the aisle are calling for it to end. This bill would allow meritorious lawsuits against officers and departments who have harmed people to go forward. It's only fair for people like Katrina and Fred and so many others whose families have been impacted by police violence. This bill is also about higher quality policing across the state. When an officer or department has a pattern of violating the law or people's rights, the bill authorizes the Washington State Attorney General's office to step in to ensure that all Washingtonians have a basic level of quality policing. Thank you, and I'll pass it on to Michael.
Great. Well, thank you, Enoka. And like Fred, thank you, Representative Thai, for working with us over these last several months and providing this space to provide a little bit about the what in House Bill 1202 and some answers as to why the Fraternal Order of Police remains supportive of the legislation. Again, my name is Michael Transue, and I'm here representing the Washington Fraternal Order of Police. We testified in support of House Bill 1202 during the 2021 legislative session. And recall, we did suggest 2 minor amendments. That said, we think the provisions of that bill in sections 3 sub 3 and 3 sub 4 are well thought out and find an appropriate balance between liability and peace officers' actions, and that are based upon employers' practices, hiring, supervision, directives, and training. A couple of things I wanted to mention as it relates to the Colorado law. Colorado law vests with peace officers as employers the authority to determine whether an officer acted in good faith and a reasonable belief that the action was lawful. If, and I emphasize if, the employer so finds that, then the employer and the Colorado law maintains that the limit for indemnification for the peace officer is limited to $25,000. Substitute House Bill 1202 has neither of these provisions, and we appreciate that. We believe that placing this authority with the employer has an inherent conflict of interest within it, and don't support a policy like that. We also don't support placing a policy on the limit for the employer's liability for the actions. I think this bill does a really good job of having the employers be responsible for their training and hiring and disciplining of their peace officers. What the law does, Enoka talked about the constitutional rights that the bill tries to bring into play with regard to the federal law. I would note that in House Bill 1202, peace officers have a defense against such an action if the officer substantially complied with their employer's established regulations, practice, procedure, policy, or training, or that action was approved or condoned by a supervising officer. If the officer proves this defense, their employer is independently liable for the injury, and we think that is good public policy. Employers are also, from our viewpoint, independently liable if the injury was due to the failure to use reasonable care on behalf of the employer in the training and hiring and retention of peace officers. We think that's a good thing that's in this bill and why we support it. We also note that employers are held vicariously liable if the unlawful conduct was within the scope of the peace officer's employment and authority. And a couple of other positive provisions for peace officers that we don't see in the California law is the authority of the Attorney General to investigate patterns or practices of conduct violations by employers, similarly with peace officers. And it does contain a provision that maintains an officer's ability to seek representation from their employer or having the employer satisfy the judgment under 2 RCWs that are noted in the bill. To summarize, while the current version of the bill isn't perfect, there is plenty of time between now and the 2022 session to discuss its elements. And again, we encourage you to move forward with it and continue those discussions in the 2022 session. We look forward to continuing to work with you, Representative Thai, other legislators, and other law enforcement stakeholders to enact a bill that provides meaningful protections for peace officers under the law and provides those protections to the family members and to the stories we heard earlier as well. So with that, thank you very much for having me, and I'll hand it back to you.
Great, thank you. Thank you very much. Enoka, is there anything else you wanted to add in this space?
Just to reiterate something that Michael said, that while this bill holds officers accountable, it does not hold officers individually or personally liable, which has, I think, been a piece of confusion during session. But yeah, the employers would foot the bill, not individual officers.
Thank you. Thank you both. And last person on the panel, I have the honor to work with former judge and state representative Mary Kay Becker. I learned so much from her. And in fact, she worked with me to lead the formation of this legislation. Judge Mary Kay Becker, welcome.
Thank you. Thank you very much, Representative Thai. I'm a retired Court of Appeals judge, and as Representative Thai noted, also a former legislator in the state of Washington. And my reaction to the events of the summer of 2020 and the killing of George Floyd was to feel like I wanted to do my part to help the state respond in a most positive way, because we can't continue to have this kind of police violence. It's so destructive of our society, and it's so destructive of the relationship, the proper relationship between citizens and the police, when people feel that police are just killers and are not taking care to be reasonable when they confront citizens. So I volunteered to help draft this bill, and it was my desire to see a bill that would allow accountability, that would allow people to sue when they have been harmed in a way that is harmonious with the statutes that already exist in the state of Washington, and that also features our own state constitution, which is very important in terms of securing citizens' rights in terms of how they can expect to be treated by the police. And so I was very happy to see this bill come into being and to be sponsored and to be considered by the legislature, and I'm hopeful that it will continue to be looked at. I just want to mention a couple of points about it. As others have noted, I mean, one thing that people sometimes react when they hear that there is a bill that is allowing for suits against the police, they think, oh no, well that can't be, because obviously, police can't afford to be sued. They can't afford to pay these judgments. And of course, that's true. And that's why the bill is not designed to work that way. As there is not going to be a judgment against the officers that they have to pay. And as Mr. Transue noted, if the officers show that in whatever they are doing, that is accused of being wrongdoing, if they show that what they were doing was in accordance with the way they have been trained, or they were directed by a superior officer to do it, they are not on the hook at all. They are not even going to be defendants in the lawsuit. So really, the bill was designed to put the accountability on the liability for paying judgments on the employers, the cities, the counties, or the state, whoever it is, the employer of the police officer. And you know, that is the way that the law traditionally works. I mean, if you hurt somebody and you're on the job when you hurt somebody, it is your employer who pays because they are the person who is best suited to keep track of, you know, who's doing what and whether somebody is properly trained. And of course, there's insurance that these entities carry that pay for the judgments if there is a judgment. So of course, you know, the employers will say and have said in response to this bill, oh, well, we can't afford to do that. Our insurance rates will go up. Well, think about that for a minute. I mean, the thing is that if police are policing according to their professional standards and they are doing things right and they are not making rash judgments and rushing into a situation without thinking, then, you know, if they are acting according to their professional standards, there's not going to be an impact on insurance because we're not going to see these horrific incidents. But think about it too, and think about when there is a tragedy, a horrific incident, an incident where the police have rushed into a situation and started shooting without using due care. If you have a situation like that and somebody gets hurt, then if they do not have the ability to sue, that means that they are carrying the whole burden of the harm that is caused instead of putting it where it belongs, as it is in every other kind of lawsuit. And so that's not fair and that's not right. And so I think that we are on a good track here with this bill to bring about justice for the families who would have the ability to sue. And also, one of the hopes here, one of the aims and the designs of the bill is to improve trust, because when there is no accountability for harmful actions, then there is not going to be trust between the citizens and the police. And that is ultimately what we want. We want a well-functioning and just criminal justice system. And so when you have these kinds of incidents, it could be, you know, the police breaking into a house that isn't the right house and hurting the people inside because of a mistake that they have made. Or it could be stopping somebody and hassling them when they're driving their car for no good reason at all. Or worst case scenario, when they, you know, too many of these incidents that we hear about is where the police arrive and within 30 to 60 seconds, somebody is lying on the floor bleeding. This is what we need to, this needs to stop. And this is a bill that is designed to help stop it, along with all the other things that the legislature has done. This is the bill that enforces the standards. This is the bill that gives the families and people who are hurt a chance to have their day in court and to bring about change in the way that lawsuits have always done. You know, there is no one else. I mean, the thing is, if you are driving a car and you hurt someone and you're driving on the job, your employer is going to pay for it. And if you keep doing it, pretty soon the employer is going to say, you know, I'm sorry, but you have to have a desk job because there's just too many of these incidents. And that's the same way it works with this bill. This is the way insurance law works. If a doctor operates on someone and hurts them, their insurance covers it. And if they happens too many times, you know, they don't continue to operate. And so we need to take advantage of that dynamic and put it into play here in this crisis that we are facing in terms of police accountability. And so I think we have a good bill, and I'm looking forward to working with all the rest of you in terms of trying to advance it. Thank you, Representative Thai.
Thank you, Judge Baker. And once again, I want to thank all the panelists who participating in today's webinar. To the audience out there, if there's any point that you heard in today's webinar that you wanted to learn more, to understand deeper, please once again contact us. My apologies for my name's being weird. It's not a simple English name, and so I'm gonna repeat my email address. It's spelled my-LINH.THAI@leg, that is leg.wa, which is wa.gov, G-O-V. And we are confident We are confident that the dedicated public servants in law enforcement will be able to rise up to the challenge and to join hand with us once they understand what this legislation is about. This is not punitive. This is about us coming together, doing the right thing for Washingtonians whom we prepare to serve. Once again, thank you for joining us. Thank you, panelists. Until next time.
Thank you.